Welcome. This is the Domain Name Law Show. We're here every Tuesday. That's at noon Pacific, 3 p.m. Eastern. We discuss domain name legal issues. We review recent UDRP decisions. Those are domain disputes. There's 3 hosts to the show. Myself, Jeff Neuman, and David Michaels. I know Jeff is unable to make it today. We'll talk about why. First, I want to say hello to my co-host, David Michaels. David, what's going on?
Oh, I'm just enjoying a bright, beautiful, sunny day with a beautiful sky, beautiful blue sky. Hopefully it's not our last. But anyway, yeah, so it's a great day.
Yeah, I don't think it's going to be the end of the world for your part of the, Earth. We don't know what's going to happen later on today. Unfucking believable. Okay, so there's some things I wanted to touch on real fast. Okay, Jeff is simply right in the middle of some lawsuits, just too busy. That's the bottom line. And I'm thrilled to say that because now I'm, working with Jeff full time over at JJN Solutions. If you have a lawsuit, if you're party to a lawsuit, you need some legal representation, reach out to JJN Solutions. Certainly if you have a domain dispute, anything domain related, but more so really business related, whether it's reviewing contracts or writing you contracts or, in business. We're in business, a lot of business folks. And if you feel like you need to pursue legal action against someone or you are on the end of receiving a complaint, reach out to jjnsolutions.com. Anyway, yeah, Jeff, you guys are familiar. He was in a couple lawsuits. He's mentioned the one against GoDaddy. That thing is right in the midst of a lot of depositions and really heating up. So that's what we're working on there. With regards to a case that we touched on last week, we're lucky enough to have Igor join us today because he was the representative. He was representing the domain owner last week. Let's check Igor's mic and see how he's doing. Hey, Igor, what's going on tonight?
Yes, hi, Todd, hi, David, and hi, everyone. Everything is fine here in Belgrade, in Serbia, and I'm glad to be on the show again. It's nice to be here with you guys.
Thanks, and that's why I said what's going on tonight, because it is late over there, right? Just after 9 p.m., is that correct?
Yes, it's 9 p.m.
Yep.
5 past 9,
yeah,
to be precise. Yeah.
Try to be aware. I like knowing what time it is where you're at, Igor. But no, it's always a pleasure. I get to speak to you sometimes a couple times a week. But thanks for joining us. Last week we talked about armoriq.ai, and we'll touch on that first. I got really no news I wanted to talk about. Well, I guess I'll tell you what. I'm going to do the news, knock it out, then we'll just get right into our cases, starting with armoriq. So on the news, if you check out our outline, dnlshow.com/outline, you'll see the first thing I had on there was really about there's an issue at name.com, and John Berryhill has been tracking it. He's been on top of it, and that is, so somebody sent name.com, this registrar, a fake email, act like they're representing WIPO, like, hey, we're WIPO. I guess they were what do you call it when you're impersonating? They were impersonating WIPO, maybe the form. I can't remember who it was, but they basically sent over and said, we're a service provider. We got a UDRP complaint was filed with us for this twoletter.com name. The registrar locks the domain name. And of course, you can imagine this was a company that's operating on their twoletter.com. Can certainly affect them. Now, normally when there's a lock, your website, the servers are locked. So if it should stay still on the website. I don't know what other things with regards to how it affects emails and so on. It seemed to me like if it's locked, it's sort of frozen, your website still resolves. You probably are still getting emails if there's been no change in any of the DNS records. But still, I need to give it some thought, I guess. What other main issues would you be running into? But John Berryhill didn't like it at all because he's like, hey, so anybody can just send in an email to a registrar, impersonate a service provider for a domain dispute, and they will take action even though they haven't proved that it was a. Okay, David, did you hear about this? And have you ever been aware of any other instance like this where someone impersonates a service provider and sends a message to?
I have not heard of anybody impersonating WIPO, but I'm sure that it has happened in the past. A lot of people think these emails are spam, and I guess now they are sometimes. We're getting people impersonating USPTO, so it's not a far-fetched that someone is going to impersonate WIPO.int. Like, who's ever heard of .int? Most people have not.
Yeah.
So they just, but a registrar should know. Their staff should know. But, I guess someone's hungover or whatever, not looking quite carefully, and that's what they just get attacked that way. I guess that happens. Maybe it's an automatic system that they have, that name.com. But what I found really interesting was because John was complaining on X, they blocked him because they wouldn't give him any answers or his client.
Yep.
So, and they won't even give a copy of the email because that email is evidence of fraud and wire fraud, and that should be turned over to the FBI. But definitely the domain owner should get a copy of it.
Yeah, what Dave was talking about is name.com blocked John, and that's rude. But I can understand why they wouldn't say, "Here's the email that we received," because it's going to become evidence, and why you share it with you don't share it with anyone. John was frustrated that it seemed that name.com protected the privacy, protected the identity of this, fraudulent email, but was not as protective over the respondent's name. Igor, you have a lot of meetings. I mean, you go to events and stuff, and WIPO, you're a panelist, and you deal with WIPO. I was saying some of the latest WIPO updates like 3.1, but I mean you know a lot of the other panelists that are WIPO panelists, a lot of the administrators over at WIPO. Have you ever heard of an instance like this where someone's impersonating a service provider?
No, I haven't heard of a similar case before, but I can imagine that this may happen again. And probably we will see more of this impersonation cases, and maybe they've happened already, but we're just not aware of them. And speaking of impersonation, I think what we have been seeing recently is fake evidence in all sorts of legal proceedings, including the UDRP disputes. Sometimes fake evidence can be submitted by complainants, by respondents. And in one of my cases, I saw like a fake US trademark registration record that didn't exist and was submitted by the complainant. And again, yes, we can see this, impersonating emails. And I think the only recommendation I can give right now is basically, yes, registrars should know which notices they get from UDRP providers. And there are 5 UDRP providers. And normally, these notices are sent, through trusted email address, by trusted email addresses. Like if it's WIPO, it's one of the case managers. If it's a Czech arbitration court, I think it is sent on behalf of the head of domain disputes at the Czech arbitration court. In case of the forum, it's again one of the case managers. And again, it should go from a trusted TLD. So if it's forum, it's ADR forum. If it's WIPO, it's WIPO.int, INT, and the Czech arbitration court again. They have ADR.eu. I think, we just have to be careful. And I think in this case, John spoke about, we don't know which provider was impersonated, actually, because I think he didn't name a specific provider, or maybe he didn't know. Maybe the registrar didn't disclose which provider was impersonated. They just said it's one of the UDRP providers. So we don't know even which one of the providers was there. So
Yeah. I mean, and right, it's likely happened before, and there's probably been registrars that have said, didn't go along with it, like knew they were being spoofed or a service provider was being impersonated. And if they are questioning it, because it could come from a legitimate email address, somebody could have hijacked an email. But there should be ways, one, to be able to go over an email and say, is there, um, you know, especially with AI, to say, can you confirm this? And then if there's any small, red flags, then reach out to the service provider and say, we did receive this, or can you confirm this going through another channel? Now, GoDaddy, I would assume, has the most domains that have, they have so many domains under management. They get the most UDRP notices from service providers. So, I mean, I'm wondering how many they get, per week, but still they should have a department that can verify each UDRP before it's locked, before the domain is locked. And then if you're seeing anything that seems fishy, of course, reach out to that service provider. But some of these registrars, I'm certain, don't get, maybe one, or if they're a medium-sized registrar, maybe 2 or 3 per week, because we know how many UDRPs. Now it's not on the top of my head. Last year, what was it like? Is it pretty much the same as the year before, but was it 6,000 UDRPs, or was it 1,800? I can't remember. Am I way off? Was it like 6 or 8,000? Do either of you guys know?
It's 6,000 at WIPO, just at WIPO, and then the other providers, I think Forum had maybe like 2,000 or 3,000, and the CAC around 900. And these are the 3 largest UDRP providers.
Thank you. And since you brought up the CAC, yeah, John was mentioning, and we were talking about, when I say John Berryhill, premier domain name lawyer. And if you have a domain dispute, I say contact, Jeff now, because he's a partner, JJN Solutions. But from Igor to John Berryhill to Jason Schaefer to Zach Muskovich, there's a group, and you can see a list of them at our website, or you can just reach out to me and I'll tell you. There's a group of domain name lawyers who, now I'm learning more, really get along, really refer things to each other, because sometimes some have higher caseloads and they need to push something off to a colleague. But you really need a domain name lawyer when you have a domain name dispute. Okay, so John was talking about there's a new, you pay $4,000, you can get WIPO will guarantee you, this is just off the top of my head, WIPO will guarantee you a decision in 30 days, something like that. But which I think, geez, sounds pretty steep, because they weren't too far off. But he brought up CAC, that service provider, actually had a turnaround time recently of 25, 26 days, and it's no additional fee. What's your experience, Igor, being a panelist and also representing a lot of, well, I'm really both sides, representing domain owners, but you also represent trademark holders. What service provider do you prefer to use? And I know you don't want to say it's like go against one or the other, but what's your experience with these turnaround times with each provider?
I'm a panelist with the CAC, with the Czech Arbitration Court, and with the ADN-DRC, the Asian provider. So I'm a panelist myself with these 2 providers. But I worked with actually 4 out of 5 providers. I have never worked with the Canadian Arbitration Center, but I worked with the Forum. I worked with WIPO. I filed at WIPO for complainants, and I defended respondents. And and with the Forum, actually, I defended respondents. I never filed with the Forum, but speaking from complainants' perspective, based on my experience and on the experience of the other people I had a chance to talk to, I believe if you act for complainants, probably your choices should be either the Czech Arbitration Court or the Forum, because they are the fastest providers in general. If it's like a clear-cut cyber squatting case, if it's very easy, and the UDRP is supposed to be clear-cut cyber squatting, So for the complainants, I would say the CAC and the Forum are the fastest. And if you happen to represent a respondent, there is a kind of popular view that you may have better chances at WIPO, because WIPO case managers maybe are more careful when they select panelists for a particular case. And I'm talking about single member panels, obviously, because yes, if your respondent, if your client has money, I always recommend a 3-member panel. But in case he or she doesn't have much money or is not ready to pay, again, and based on my own experience and based on the experience of some other lawyers who represent respondent, there is some kind of belief that maybe as a respondent, you may have better chances with WIPO. But again, it's not up to respondent to decide. Respondent has to defend, any provider the complaint was filed. But that's kind of, just my view. And speaking of WIPO, just to add that we are doing our 3rd conference in Belgrade in Serbia on April 27th. And it's going to be about brand protection, domain names and trademarks. And actually WIPO is coming to Belgrade for the very first time. And this lady, Charlotte from WIPO, who is a senior legal officer, is going to talk about this expedited UDRP introduced by WIPO and some other updates. So I'm looking forward, to hearing more from WIPO, including, this update, the expedited UDRP service.
Make sure my mic was on. Yeah, Igor, I think that's great. One, I'm glad you don't have to travel far to go to this event coming the 27th, and I look forward to you asking Charlotte about, I think we talked about how these cases are designated out to the panelists, meaning some seem to get hundreds per year and some get, in the single digits or low 2 digits. But interesting that they're having it right there. And I think that's great. It's fantastic. I know you've been going to events and it seems like now some of them finally coming right to you, but that's great to hear. So we'll look forward to some feedback on that. That's April 27th, you said, in Belgrade. Pretty cool. David, I want to ask you, and then Igor, maybe you might know as well. Okay, so when a domain is locked, David, like I said, when there's a WIPO or there's a complaint, and then they lock the name, the DNS stays the same, and so the website still resolves, and they should still be getting emails. What am I missing here when a domain is locked? Of course, if you're just a domain seller and then you're like, hey, I was wanting to transfer it. Of course, you can't transfer it. I was wanting to sell it. No, you can't. It's locked in that sense. But what am I missing? If you're a active business, your site should still be up and you should still get emails, correct? And then what would you not be able to do?
But here's the threat. So my website's still running, everything seems fine, but the domain is locked because of a pending UDRP complaint. But I want to respond to the UDRP complaint because it can be potentially transferred under a WIPO decision or UDRP decision. So if I don't have a copy of the complaint, I'm starting to get very antsy because my business depends on it. I don't want to lose this. I don't want it to go dark. I don't want to file a lawsuit. So it's essential to get a copy of the complaint. And if they can't even tell you what the complaint number is or which provider it's with, then that's a problem. And I remember that John was saying, hey, I checked. I think they said it was WIPO, and he checked. WIPO publishes all their active cases online, so you can check to see if it's an active case. They won't tell you the details, but at least give you a case number if you type in a domain name. So, yeah, that gets very stressful if you're running a business with that name.
Yeah, it seems like they should at least check WIPO active. You're right. And now there should be an automated thing. You get an email, you're a registrar, you get an email, it should automatically, it's like trigger an auto reply, but instead of an auto reply, an auto check on WIPO or whatever service provider to see that it's active. Igor, you've represented domain owners, so when they receive a complaint and their name's locked, what complaints have you heard from respondents who are like, my name's locked, I can't do this? What is this they can't do?
Well, in my experience, some of them were just frustrated because they saw this change of status saying that the domain name is locked. So they just didn't like it. And yes, obviously they cannot transfer the domain name if they want to. But again, in case of my clients, they didn't want to transfer it. They just maybe wanted to update some content. And yes, the content is still there, and you can use an email. I mean, you can use your emails. That's true. But for some businesses in particular, even like this status of like locked domain name can be frustrating.
Okay, we're going to get to our cases, but last thing on the news was basically somebody made a comment. We were talking about, John saying, hey, this company, there was a fraudulent notification about a filing, and it locked this registrant's domain name for no good reason. Well, then people were making the comment, well, isn't it, it's $100 now you can get a domain name locked, and that can cause a lot of problems, and some crypto bro with $100 in his pocket could cause a problem. First of all, you can't do it for $100. It's going to cost you the full filing fee, and then once you get that information you wanted, they were talking about you get the registrant's name. Say you're a complainant, you still have to pay the full filing fee, and then what WIPO would do is if you immediately after you get that information that you're probably looking for, the registrant information, then if you cancel immediately before anything else is done, before the registrant is notified, before a panelist is selected, then you can get a refund of everything but $100. Okay, so that's why they were saying it's a $100 cost to get a registrant's information, but it is, you do have to file, you have to pay the full fee up front and then wait for your refund. So, there's, some smart thing to do in some cases. And then finally, I'll just say, yeah, you can file up to 5 different domain names for that one filing cost. And then if you've got these 5 different registrant names, information, then you could cancel real fast, get your money back except for $100. Then it would actually be only $20 per registrant information that you were out to get. But I wouldn't be surprised if you don't cancel quickly, and then your refund, you still get a refund, but it's, I think, down to, it's going to cost you like $350. But anyway, because I want to clarify that. If you want to follow our cases and check out the links, go to DNL Show. It's domain name law. DNLshow.com/outline. You can see. So last week, the first case that we went over, and I was certain hoping Jeff was going to be here, but guy is so busy. Oh man, is he busy. Big deposition tomorrow too. Okay, so he was the panelist on this. And I'll play his role a little bit. The domain armoriq.ai. So it was one we touched on last week. We're just going to touch on a little bit today because Igor represented the domain owner in this case. And we told you last week the domain owner was successful. Igor effectuated a positive outcome for his client. And it was also ruled by Jeff to be a reverse domain name hijacking. Okay, so Igor, this complainant was a UK company on, that filed this complaint against this .ai domain name, and they actually had offered a physical product of armor. I don't know what they offered. You can tell us, what was the complainant's case? How did you defend it? And I mean, I'm sure you agreed with Jeff's decision, but how do you think he arrived at it, considering the complainant's evidence versus in then your response to the evidence the complainant submitted, please.
Yeah, actually, the complainant was a U.S. company out of California. So it's an American company, and the respondent is American as well. So he's also from California. So both parties were from California. I mean, the interesting thing about this case was that the complainant, even though it's a U.S. company, U.S.-based company, they don't have a U.S. trademark. They only had 2 registered trademarks. One is in the European Union, and the second one is in the UK, in the United Kingdom. I think that's why you kind of thought that they must be in the UK or somewhere in Europe. but they're in the US. And in the United States, they have a pending trademark application that was provisionally refused by the USPTO. And that US trademark application was filed as an intent to use application. So they didn't submit proof of actual use of the mark in the United States. And my client, basically the respondent, he's an investor, but not a domain investor. He's a startup and technology investor. So he invests into startups and tech businesses. And he's got some, impressive portfolio of startups he invested in. So this armoriq.ai company is one of the companies he invested in. And he registered this domain name basically for this startup. And I think the main thing about this dispute is that there are two parties. Both are from the United States, both are from California, but they're doing completely different things. The complainant is manufacturing physical products like armor plates and vests and like kind of protection equipment, and basically goods designed to protect you from bullets and all the other stuff. This is the complainant, and the respondent is providing technology services AI related. So basically they're creating a safe environment for AI agents and kind of providing technology to control AI agents, the way they operate, to make sure that they don't go beyond the boundaries. So completely different fields of business. The other interesting thing was that the complainant, they have the .com domain name, exactly the same domain name, armoriq.com. And I think that kind of made them believe that because they own the .com domain name, they can go after the .ai domain name. And frankly speaking, I don't understand why they wanted to get this .ai, because right now they're doing nothing related to AI or related to technology, related to software services, artificial intelligence. They claimed in the complaint that they might consider moving into AI business in future, but there was no evidence absolutely that they were doing something AI related. So they basically claimed that, look, we have the .com domain name. We registered this .com domain name back in 2023, and then the respondent registered the .ai domain name in 2024. So therefore, we have some kind of priority. But then they didn't try to address, the fact that they only filed the trademarks in 2025, like a year after the respondent registered, his domain name for his startup. And so basically, there's just two different kinds of businesses, different types of businesses, no overlap of goods and services whatsoever. And again, in my view, the only thing that why they wanted to get this .ai domain name is that because they own the .com, and maybe they like this .ai domain name, and they filed a UDRP complaint.
Yeah, thanks. And thanks for correcting that. 1 week goes by and I forget everything. But yeah, I remember it was a California company. And Igor, how did you defend that Armor IQ is not, unique or fanciful, that it was actually descriptive, meaning Armor and IQ isn't, so unique. It basically can, like your client is using it in a completely different area. But what do you recall about your response, basically your defense that Armor IQ is not unique? Those are two words that make sense together, as a brand.
Well, we basically just explained the story behind this name. So we explained why the respondent chose the name armoriq.ai, because armor means protection, and in our case, it's creating of a safe environment. And then IQ basically meaning something intelligent. And AI obviously, is a clear reference to artificial intelligence, because the whole, startup, the whole project is related to controlling AI agents, controlling artificial intelligence, and creating a safe environment for artificial intelligence. So basically, we just explained the story behind this domain name, why he chose the domain name, And okay, the .com was taken already, and obviously my client saw that the domain name was taken. The .com domain name was taken. We didn't argue that I had no idea that there was no other company, but we said that look, he saw the domain name was taken, but there was nothing that would somehow indicate that this .com domain name is related to the services my client was interested in. And at that time, my client registered this .ai domain name. There was very limited content on the .com website, and that content again was related to physical goods, to armor equipment, to plates and vests, protection vests, and plates. Nothing related to artificial intelligence, nothing related to technology services, and he had all the reasons to believe, okay, I can register this .ai domain name for my AI related project. And the fact that there is another company doing something with the .com domain means nothing to me, because they're doing something different. So that was our, let's say, we basically argued that we're doing a legitimate business, bona fide business. The website of the respondent was fully developed. There were even names of the advisors, founders, and the name of the respondent. This gentleman who registered the domain name was there as well. Description of services was very detailed. So I think, in our view, and Jeff agreed with our view, it was very clear that there are just two very different businesses, and our business is bona fide, and the website kind of spoke for itself.
Yeah,
we think.
So it was so important that the respondent had your representation, because without it, a panelist can certainly assume, that okay, maybe he registered the AI, he knew there was a .com, he might have been aware of this owner, meaning it's okay to be aware of somebody using another extension. It doesn't mean you're targeting them, because we know many times, Igor, a person will check, okay, I want armoriq, and they check and they say, okay, the .com's taken, and then they look at other extensions and they realize .ai, that's really suits us even better. We're glad that's available. Let's get it. It doesn't mean you're completely aware of who's on the .com. You just know the .com was taken. And sometimes, their companies will do more research and realize, okay, we are going to go on the .ai. Who is on the .com? And then you search and you realize, fantastic, they're in a completely separate business. And then you're thinking, good, there's going to be no confusion. Not so you're not necessarily infringing, but then really just to make it simple on your client to know that they're, you're not doing something that's going to be confusing to your base, like I said, to your clients. Now, there are a couple cases we're going to start getting into them right now. And Igor, I hope you can stick around and just...
I just want to actually add one more thing to this analysis. So the complainant is Maya Holdings, and the trademark application is under Maya Holdings. But the company that's actually using the .com, armoriq, is actually armoriq LLC. And you cannot apply for a trademark with the USPTO under a holding company and expect to have a valid trademark registration. It's void ab initio, because either the parent company can apply or the actual operating company. But if they're both LLCs, it doesn't look like it's, the applicant is actually the operating company. It should be the actual operating company specifically that's getting the trademark. If it's a subsidiary, then it's for sure void ab initio or a separate holding company.
I think that's an interesting point, definitely. And they tried to rely on the US trademark application when they were arguing, the trademark rights. They submitted this USPTO record, but then obviously we said that, look, the trademark application is not enough for the UDRP purpose. First, second, it's still pending. There is an office action, and it was submitted as an intent to use application. So I think the complainant was the US trademark applicant as well. I don't remember exactly. Or maybe there was another complainant's company, but I don't recall there was any issue. But I think, yeah, basically we just explained, like, look, they don't even have trademark rights in the United States, and the United States is the home jurisdiction with the complainant. But I just wanted briefly maybe to address this final point of reverse domain name hijacking, because I wasn't sure whether I should ask for an RDNH, and I did ask at the end, and Jeffrey granted this and agreed that this should be an RDNH because the complainant was self-represented. They didn't have a lawyer, and this was not a very strong complaint. To put it mildly, they tried to, argue, but they didn't cite to the WIPO overview, for instance. There were not any case citations. They didn't address this timing issue. And they were basically trying to argue that, okay, we have some trademarks and we have the .com, we've been using this, but they didn't even provide screenshots of their own website. So actually, I provided screenshots of their website by showing that, look, they're completely separate businesses. So it was, let's say, not very good complaint. It was a self-represented complainant, but then I felt like, look, this is not an excuse. Even if you don't have a lawyer, but you could have read, some materials about the UDRP, you could have looked at the forum website, you could have done more work. And this is not an excuse if you don't have a lawyer. It's not an excuse for filing bad complaints. So eventually we asked for an RDNH, and basically Jeffrey granted RDNH. So that was our point.
We're seeing more and more. I mean, we get conflicting stuff in some of these answers from panelists, some of these decisions, and that's, you're a domain investor, you have a duty to investigate, basically to do some research to see, is there a trademark owner on this name, in some capacity. And it's weird because what do they mean on that name? Only if it's an exact match of someone's trademark, or if your domain includes someone's mark, but basically they're just saying if you're a domain investor and you're acquiring a name, singular or a portfolio, you need to, check these names. That's what some panelists say, and we're going to see it in these upcoming cases. And then Igor brought up, we're seeing all sorts of basically bullshit complaints, not accurate information, but not just from the complainant, but also from respondents. And then we see people impersonating, as we talked about earlier, the actual service provider. But there's just a lot to need to be careful. Is it a real complaint? Is the complainant really the mark holder? Because now we're seeing some people say, look, I have this mark, and they give, like an Igor had an instance of just gave a fake trademark number, a registration number, and he realizes that number is too long or doesn't make sense. So, and then they put together these complaints, and we're going to talk about one now where it's got some inaccurate information. Our first case is the domain name is WFGB.com. So it's a 4-letter WFGB.com. No vowels, no V's. Sounds like a Chinese premium. Anyway, so that is the disputed domain name. The complainant in this case is Transamerica Corporation, represented by a big law firm. They're out of Georgia. The respondent, which just says admin team out of New Jersey. David, okay, so I feel like Alan Limberry, who's the single member panelist in this case, made up for the one I didn't like Alan's decision last week, and that was, I don't remember what that was. Oh, that was Movement, Movment. He transferred that name away, and I really didn't like that decision. But Alan plays golf a lot this time of year. I guess it's winter in Australia. Don't get to talk to him as much as I did before. But anyway, David, tell us about this name, WFGB.com, this dispute. Tell us why the complainant filed it, how the respondent answered, and go ahead and give us the decision, and then I'll chime in and Igor can comment as well.
Well, the complainant has a trademark for WFG registered in 2013, but WFG is just a trademark registered 9 years after the domain name was registered. So that doesn't work. So that right away is like, you can't have retroactive bad faith. There's no such thing. It's already been discredited. And there's several, they cited some cases called JAPI and Octagon for bad faith retroactively, but that does not satisfy the policy. And those ideas have been rejected in many subsequent decisions. So yeah, it was reverse domain name hijacking. There's no bad faith because the domain was registered 9 years before the trademark was even applied for.
Well, one big thing in this case that the respondent mentioned, hey, this complainant basically they had filed a case before for the domain was transamerica.au. Okay, so this complainant had filed a UDRP for transamerica.au, and they, according to the respondent, used that same complaint and only substituted the domain name WFGB in place of transamerica.au and said all these websites and all these screenshots and everything that they're saying was related to our website WFGB. Those aren't our pages. Those are pages from this website transamerica.au. Basically, this complainant took this old complaint that they had filed, substituted our domain name in there, but all the other evidence was related to that other domain name. So this complainant, obviously failed to make their case. They submitted all sorts of fake evidence, fortunately there was a response, because if there wasn't a response, as a panelist, start thinking, okay, so I'm assuming all this stuff, they don't do much research of, let me check all these pages that the complainant has supplied and make sure they're on the URLs that they said it's on this disputed domain name. So I thought that was, obviously a pretty big deal. And, the domain owner won in this case. I don't expect that you read this case, but that's pretty egregious, huh? I mean, have you experienced that where a complainant adds all sorts of evidence it's related to another domain name, Igor? Just basically a complaint that's full of stuff like, hey, they changed their MX records when in fact they didn't. I mean, basically I'm saying you have run into complainants just making false claims, and if you're not there to defend them, sometimes they can slip through to a panelist and, panelist believes it.
Well, yes, certainly. I've seen some of the cases where, the complainants made some claims that were either baseless or outrageous, or, sometimes they copy pasted something from one of the previous complaints. And yeah, this happens sometimes. And, especially with the use of AI, you can see all sorts of, fake citations, non-existing cases. I mean, in both complaints and responses. So it's not only about the complainants. I think what's interesting about the case, and I looked at the decision. I didn't really have enough time to read it carefully, but what I noticed that actually this was not in RDNH. So the complaint was denied, but ultimately the panelists didn't make this RDNH finding at the end, because the panelists said that the panel is not persuaded that the complaint was brought in bad faith in an attempt at reverse domain name hijacking. So I think that was interesting, despite the fact that the complainants counsel, cited this retroactive bad faith cases that are no longer the right authority. That's kind of interesting. And the complainant in that case was represented by a law firm. So I don't know. I think maybe what kind of made the panel, decide this way, so not finding an RDNH, because the respondent was not the original registrant of the domain name. As David said, that the domain name was registered originally prior to the trademark registration, but then the respondent was a subsequent registrant. So maybe that's why the panel decided that this is not an RDNH case, but don't know.
Yeah, the disputed domain we're talking about here is WFGB.com. And I think, okay, and you're right. Thanks for, clarifying and correcting that there wasn't reverse domain name hijacking ruled. And I think it may have had to do with, and I'm probably, who knows, is the respondent said, hey, WFGB, that's a radio station. They have senior rights. All right, well, but you're not affiliated with that radio station. And you brought them up a few times like, hey, you keep pointing to WFGB. All right, well, are you saying, it doesn't help that when you point to them to say there's a senior user, you need to add on to it that there's, basically there's other legitimate users for this. He's pointing to them like that's the person who has rights to this name. and it's not showing that you have legitimate rights by telling somebody else has legitimate rights to the name. You need to still show, so what are your legitimate rights to have this name? They're known by it. You're not known by it. You're saying they have legitimate use. Okay, we're talking about you, not about this radio station. And then the complainant, followed up with a supplement, and it seemed like the panelists took it, if I remember this case correctly, and that is said exactly that. Well, they're admitting they don't have rights. They're saying this radio station, and they're not affiliated to this radio station or any connection at all. So what are they saying here? So anyway, no reverse domain name hijacking, but the panelists did say WFGB is not, is not really similar to WFG, but they said that, and then they ended up saying the complainant has established this element in the case. So he did find that, it was, just differing by one letter, but just the weirdest thing. But anyway, so when I saw that case, I brought it up because it was a 4-letter. I was hoping it would be a complaint denied. It was complaint denied. This company, World Financial Group, I looked at WFG.com. That doesn't even go anywhere. Have they ever went after that name? It seemed like that's the one they would want, WFG. That doesn't really go anywhere. I assumed the domain owner owns it. It wasn't resolving for me. And it doesn't matter who the complainant is on here. I was looking to see what domain name that they use.
WFG was registered in 1992, which is a really early name, and has AWS name servers. So it's common that these old domain names, have outdated servers and are no longer in use, but that doesn't mean that it's not theirs. It's registered through CSC corporate domains. So I think that means it's a big company that registered it.
Yeah. Sometimes having a page like that works in your favor. It doesn't resolve, never has. And then we're finding sometimes it's a negative for you depending on the panelist. We had a conversation about this last week about how some long time, people that registered names 30, 35 years ago haven't touched them, haven't done anything with them because they don't want to make any wrong moves. But yet I see some decisions where by not demonstrating how you're going to use it in a legal friggin' way, in a non-infringing way, if there's somebody else with that mark, you got to show that you've done something with it. But then we see, like I said, conflicting where some people haven't done anything for 25, 30 years, and that seems to be their best defense or their strong defense. This next case, so at WFGB, stays with the domain owner. This next case is masalo.com, Masalo. Not knowing, to me, if I saw that, I'd think, sounds like a last name. It's probably a word in Spanish I should know, or in some language. Seems pretty, I have no idea. I don't know any companies under Masalo, but I assume there probably are companies. But if I saw the name, I think, as a domain investor, we go after those types of names. CV. That's my Poland, CV. Okay, so seemed like a good domain to me, masalo.com. Okay, so in this case, the complainant is Masalo KG. What's KG stand for anyway? Where are they out of? Germany. What's KG stand for? Anybody know? Something like Inc. or something. Anybody? When I say anybody, I mean...
I'm not sure, but it's a certain type of entity within Germany.
Yeah. I'm sure it's some 2 long words, and they stand for, enterprises or incorporated. All right, so that is the complainant, and there is a Chinese domain owner here who is on the receiving end of the complaint, and Matthew Kennedy, solo panelist here. Let me go down, remind myself. Yeah, this was okay. So basically, the complainant here had been using the trade name for a long time. I guess they had a registered trademark in Germany. I don't have the date handy. I don't know why I don't have the date handy. I do know the domain was created on March 5th, 2010, but the respondent acquired it at that time. So the respondent in this case was the original domain registrant. So their basically response was that the trademark rights were acquired after they, after they acquired the name, after they registered the name. Very simple. And I'm in China. I didn't know about them. There was no common law mark that was well known before I registered this name, and any rights that they had to it was over in Europe. It was geographic. So this respondent was pretty straightforward in his response. Just said that the domain's not even being used commercially, and even though there was, I think, a broker reached out to this Masalo company in 2020, that didn't prove any bad faith or anything like that. So then the panelist, before I get to the panelist decision, David, any comments you want to make on this case? And then if you want to, go ahead and say how the panel decided and why they decided that way.
Yeah, so the name is actually a surname and a forename in Africa, different countries. I think Togo and something. But yeah, there's 19 trademarks for Masalo. The complainant owns a bunch of them. It's actually Ulrich Rogers, I don't know how to pronounce with R-O, maybe Ruder, R with a umlaut on it, D-E-R. And there's a company in Spain has a different trademark. There's a company in India. So different possible owners out there. And yeah, it was denied because of the dates, and there was no evidence that the respondent knew about the complainant when it registered the name, and so that's why it was denied. The respondent was self-represented, which is rare that they actually win, because usually if you're self-represented, you don't know what arguments to make. But this one successfully argued that, yeah, they didn't have it being in China, they had no reason to know about the complainant, and when they registered their name, and there's no bad faith. They skipped part 2, they just went to part 3. And they coexisted for years.
I mean, it was nice to see a domain owner answer himself, and this person was from China, saying, I have this name, I got it before. You think that should be it. I got it in 2010. They didn't have trademark really anything registered that was, and it still wasn't well known, but not till 2014, 2017. So should be cut and dry. At least they answered. If they didn't answer, who knows how this could, go down. But they seem to have a lot of defenses there, and they didn't really go into them with regards to this is a surname. I invest in other names, because usually you do want to load up with your response. That's why you want to have a professional help you to make sure you have hit, a lot of your different defenses, because sometimes one of those really sticks with, or how they resonates with a panelist. This panelist, I think, always makes some pretty good decisions. That was last name Kennedy. It was Matthew Kennedy. Any comments you have on this case, Igor? Masalo.com.
Well, my first comment, would be that it's great that he responded, or he or she, this respondent, because yes, this person was self-represented, out of China, and in my experience, when I see respondents from Asia, can be China, Korea, other countries, often they don't respond. Maybe it's a language issue or something else, but they don't respond. And if you don't respond, as you rightly said, that you may lose a case. You may lose a case that you otherwise, could win. And he responded himself, provided some explanations, and this worked very well. And it just shows that how important it is to respond sometimes, even if you don't have a professional representative. Just explain your story. Just explain how you bought this domain name, what you did with the domain name. And I understand that maybe the respondent didn't provide very detailed explanations. For instance, why the respondent decided to choose this domain name, history behind this, but at least, the respondent provided, some information when this domain name was registered, that this domain name was used for email, for sending emails, and that was enough. And I think another notable point was, the panel made this finding of no common law trademark rights, no unregistered trademark, because the complainant tried to argue that they have common law trademark rights, and they tried to rely on the company name registration. And that's quite common thing in Germany, because I had some German complainants, and very often they rely on company registration when they argue the first UDRP element. But the first UDRP element is trademark right, not a company name right. But in Germany, company name enjoys some protection as intellectual property, and some German lawyers believe that the company name equals trademark, which is not true. So they tried to make this argument here, didn't work.
So the two cases we've covered so far today, WFBG or GB, doesn't matter, .com, that was ruled complaint denied, stayed with the domain investor, just like this one, masalo.com. The panelist, Matthew Kennedy, ruled complaint denied. The complainant hasn't made their case on that this one wasn't registered in bad faith. This Asian domain owner gets to keep the domain name. Great. This final case frustrated me. That's why I put it on there. This was a transfer, I'm already going to tell you. So the domain owner lost the domain name, and we'll get into why. The domain is expectancy.com. Expectancy.com. Without the E at the beginning. I titled a film Exchange several years ago without the E, because a lot of people, especially names that begin EX, existential, I mean, you can get rid of that first E and it's almost, still pronounceable with the X at the beginning. And we know words like X-ray, right? But the point is, so expectancy, this person ended up registering expectancy without the E at the beginning. The domain was registered on, it says October 4th, 2025, which tells me the respondent, they did acquire it at a GoDaddy closeout. And the complainant here was a company called Expectancy out of Texas. The respondent was a domain investor out of Texas. Sounds a little like you, Mike. Got Mike G in the crowd. He doesn't like to be called out. He was just called out. Okay, so a domain investor out of Texas bought this name. And the long story short is this panelist said, after they, I'm going to wait to say what the panelist said. Maybe David will say. But David, tell us a little bit about the complainant's position and the respondent's position for this name, expectancy.com.
So the respondent said that the domain was registered in 2021, which predates the complainant's trademark, and they didn't know about the complainant. The panelist didn't believe the respondent because, oh, you're both in Texas, so you should know about each other. Really? Like, I just Googled expectancy and there's no answer for any kind of company on page one. All I'm getting is dictionary definitions. And I think that's the major feeling of this response. The respondent could have said, hey, it's just a dictionary word or adjacent dictionary word, because when you Google expectancy, you get, with the X, you get the correctly spelled word coming out. And that's all the search results you get on page one. And the panelists, obviously didn't consider that. But, the trademark was applied for, I think it was in 2024, and they claimed interstate use since 2022, with the first date of use on November 24th, 2021, which is 3 months after the domain creation date. And the panelists didn't do the complaint any favors here, because, as a domain investor, they're aware that they can file a court case in the district court in Arizona and overturn this decision. And the complainant is going to have to pay legal fees. It's going to cost them a lot of money. If the complainant was smart, if the complainant was smart, they would just bought the name. If the panelists were smart, they would have said, you know what? Okay, you say you didn't know them. There's no notoriety. If you Google them, they're not online. So just deny the complaint. That's what should have happened. But in this case, this particular panelist has a habit of acting on behalf of the complainants, and that's wrong. What do you think, Igor?
Look, first of all, I have to say that I have to be very careful here because I know the panelists very well. And I was in France like 2 weeks ago at a conference, and I was with this panelist because she was one of the moderators of the roundtables. Uh, and yes, she's very well known in the brand protection industry, and she's a very prolific panelist, and she represents complainants. Uh, in my view, my impression, again, I didn't see the submissions, and it's hard to again to say how strong the response was and how well the respondent argued his case. But I think what, let's say, made a difference here is that yes, the both parties are from Texas, and that kind of maybe persuaded the panel that the respondent either knew or should have known about the complainant, and the domain name was dropped, and it was previously registered by the complainant again. And I understand why domain name investors are not going to be happy about decisions like this one. Whenever panel any panelist says that, look, you domain investors, you have this obligation to search prior to your registration of any domain name. So whenever you register a domain name, you have to do some searches and see whether there is a trademark or a company that's using a similar name. And basically here is what the panel said, that domain name investors have this higher obligations to search. But that's, again, I mean, I understand why the main investors are not going to like this decision. Not seeing the submissions, it's hard for me to say something more definite about this case. But I understand why why people can argue about this case. Let's put it this way.
Um, I was going to say, so these panelists, and it's Natalie Dreyfus who decided on this one. They're grown people; they can take it. Like I said, I didn't agree with Alan's decision last week, and then I say I didn't have a chance to speak with Alan, but I was saying to him, of course, Alan, I only see the bullshit that we get, and that is this summary. It's not the real complaint, and it's not. We don't get to see the full response, and we're only seeing what we see, but sometimes just things seem to be missing. And so we went like, fill in the blanks for us. How did you transfer? That's what I wanted to ask Alan. How did you transfer MOVMENT? And then I know Karen, she ruled on a case HCL.ai, and they transferred that away. And how I always felt, I felt like panelists should, in that case, certainly ask, would that domain investor have purchased that name, even if that well-known, and this is an Indian mark holder, HCL, if that well-known mark holder didn't exist at all, would that a domain investor still have acquired that domain? And my answer to that question was, yeah, that was Narendra in that case. So that domain investor was going to acquire that name, no matter if he was aware of this big mark holder, if he wasn't aware. And like I said, just being aware that someone has a trademark with those letters or a word doesn't prevent you. But anyway, the point I was making too about, many times all I see is these summaries, but still I'm like, that doesn't make sense to me. That's a bullshit, decision. And then sometimes they'll come up with, here was some things in the complaint that you didn't know that this person did work for them, or there was a relationship, or there's just something that wasn't in the summary. Like, why wouldn't they put that in the summary? But many times there is evidence we don't see, and part of a response we don't see, and then it sort of clears up why the panelists said, hey, and we, So in this case, Natalie said, what I didn't like about it at all was it looked at like the complaint was a cookie cutter complaint, meaning they say the same thing. We have trademark rights. Number two, they are not known by that name. So we know as domain investors, I'm not known by a lot of my domain names. Okay. I'm not going to go into them, fucking thousands of them. Yeah. I'm not known by this. I'm not known by that. I'm not known by Sky 14. Okay. I'm not known by 93rd Street, whatever. So so that's common, but complainants often bring that up. This person's not known by that moniker, and then and they're not using it at all. In this case, basically, Natalie said, we know it was a bad faith registration, or we assumed it was, because when this name expired, they immediately got it. So they didn't. They immediately jumped on this name as it became available again, which doesn't make any sense. But she also stressed that a professional domain investor is expected to do due diligence before acquiring a domain identical to an existing mark, and that respondent, in this case, failed to do so. I'm not mad at, like I said, I've seen some decisions where I think smart decision by this particular panelist, but they're all grown-ups and they can take, well, here's the reason why I did it. Well, in this case, it looks like a cookie cutter complaint. No, nothing there, at least I didn't see. And then it was basically all on this. They were both from Texas, this Texas domain owner, to say, you should have looked this up. And he did. He might have known it, but he knew basically, all right, so I'm in branding. I'm in a whole different area of business. So what the complainant did wrong, and this was according to the respondent, he said the complainant assumes that they have the rights to this word in every extension and any domain name. Now, of course, they wanted the .com. They lost it. They forgot to renew it. And so anyway, and I really like that response that you have maybe this mark, this particular name, and it could be a fanciful word, it could be a dictionary word, it could be whatever, but you don't have the rights to it in every extension. That's just a fact. I don't know why that's hard, but anyway, the panelists just felt like, hey, if you're a professional domain investor, you have to really do your research. And then they want you, it's not that even when you do the research, they want you to come to the conclusion that they would come to. But most of these panelists, and Igor, you've heard me, speak to some panelists too, that I'm like, geez, some of them are just so heavy-handed on the brand side that it's like, we do the research, the same research you would do, and we see it differently. We see it like, great, there's several companies that are using this name, but I plan on using it in a different fashion. And what the good news is, well, one, maybe I'm not going to use it. I'm a domain investor, so I'm going to put up a for sale lander real fast, and I'm not going to reach out to any of these mark holders, even though I should have a right because there's several of them, but I know that could look like I'm targeting, so I'm just going to put up a for sale lander, and then that, to some panelists is bad faith right there. But anyway, so this one, I just didn't see anything solid in the complaint and that made it like, okay, you own this word. They, in any extension. So I guess expectancy without the E at the beginning. If you owned it in .tech, well, if they want it, they can get it from you. Basically, even, with the same sort of thin complaint of, you better, I don't know, I guess you better put it to work as a fucking car dealer or something, a legitimate business real fast in some other industry, and it still doesn't mean that you would win a UDRP complaint.
Yeah, if I can
Yeah.
just, if I may add, Todd and David, I mean, when it comes to this obligation of domain investors to do some searches or whatever, trademark searches, company searches, I think this is one of the UDRP areas where we still don't have like a full consensus. Because some panelists think yes, you have to do some searches. You have to search USPTO database, some other database, or do some Google search. And some other panelists may say, no, you don't have a general obligation to search, and then you cannot ignore like a famous trademark. If it's like Coca-Cola, yeah, you cannot ignore that, and you cannot say that I've never heard of Coca-Cola. But no general obligation to search. And here is one of these gray areas where I think there is still no consensus, and different panelists have different views. And I mean, what we are trying from our side, again, I'm just getting back to our conference in Belgrade, we try to bring together, providers, panelists, and investors, because on our domain name panel at our conference, we will have a domain investor as well. So at least we're trying to, create this environment for dialogue, for conversations, and then hopefully provide better education for all, and maybe some kind of debates and and just to keep this conversation going, just to show that it's not always black and white. And I hope we can contribute. And some panelists don't really understand how domain investors, work, how they make money. And yeah, I think that's what I'm trying to kind of bring people together and bring stakeholders together, bringing investors and panelists and providers together. So I hope this will contribute maybe to some good decisions in future, maybe to better understanding of how this industry should function and what kind of obligations domain investors have, if any.
Yeah, and thanks, Igor. And not all domain investors are created equal. I mean, it's nice when you have, I know you had Sten there before, somebody well-spoken, smart, really, a domain investor that invests in brandables. The ultra domain investor, in my opinion, is a friend of both of ours, Nat Cohen. Okay, so Nat, it's nice when you have a domain investor like that really understands the UDRP as much as any panelist or any complainant or any respondent, in my opinion, and owns names that you can really make a case for. And what I mean, like say a 3-letter or a generic word. But when you start getting down to domain investors who are like the rest of us, we're in the middle of the pack in the marathon. We're not the leaders. And then all of a sudden we have names that are, all right, well, we're not as established. And then basically, like I said, not all domain investors are created equal. And then you might have a few in your portfolio that are more questionable, but basically you're just a domain investor. But you're right, like you have a for sale lander on a lot of them. Some of them seem to be fine because they're a brandable. Some of them include, oh no, it included their name, and they're also they're on the they're Galaxy Capital, and you have Galaxy Finance. Oh no, should you have done that? I guess the point is it is important to have, and thank you. When you've participated in events and especially helped put on sessions, you've included domain investors, because I notice when I talk with panelists, basically just some trademark lawyers, they act like, yeah, we know your fucking game, and that is you guys want to buy names and then you want to sell them to a mark holder for big money. Well, I wish guys like Andrew Rosner and Andrew Miller and these top brokers would, they're scared of lawyers too, of losing names, even valuable names, but get in and say, this is an asset class. Domain investing is legitimate. And we're not saying that domain investors don't need to do some due diligence, but it just, they want us to come to the same conclusion that they would come to. This is a trademark owner who doesn't own any domain names, and he's like, I searched Google and I searched the trademark USPTO site, and I can see there's several, so I wouldn't touch that name. And we're thinking just the opposite. We're running into the house, the fire. We're firemen. You're like, no, that's too dangerous for me. We're thinking just the opposite. So, and we're thinking just the opposite because we think there is something to retrieve there. There is something worthwhile there, and we have rights to it, and we want to make sure that we don't infringe on anybody else's rights. And, domain investing was always, first come, first serve is a real important point of domain investing. And sometimes whether it's a new extension or something drops, whoever gets there first, and then you get there and you grab it, and now you may have some more limited rights on certain names because there may be a lot of mark holders in certain classes that you're going to have a tough time, doing something similar. But I guess, I don't know. It's just a bunch of talk. Hey, David, before we shut this baby down for today, any comments or final questions? Let's see who we got up here. Brad has a question.
Yeah, definitely. So if you cannot afford to hire a full, representation for your UDRP complaint, at least, send me an email. I'll do the searches for you. I'll do the background information for you for an affordable fee, and you can submit your response on your own, and hopefully you still win. We've been talking about these cases now for what? Now it's 5.5 years, and I think I've got it down pat.
Yeah, that's awful nice. What email should they send you, Dave? I know you got a couple. What's the best for this?
Yeah, just send it to David at trademarkpro.ca.
David at trademarkpro.ca. And like David said, he can assist you checking, doing some trademark searches, and then you'll know, and obviously can respond. Well, that's even responding to cease and desist, but definitely UDRP, and then hopefully never a lawsuit, but also just to know where you're at with the name. If you're building on a name, definitely like to reach out to an attorney, to be able to say, hey, here's my intentions. Can you, help me prepare, or anything I should be aware of? Hey, Brad, thanks for joining us. What's going on with you? What question or comment did you have?
Hi, thank you, Todd and David and Igor. My question is, if this domain owner had a lot of names that started with X, that was one of the things that he, focused on for his domain investment portfolio, do you think that would have made a difference?
Anybody want to answer? I would say in most cases, yeah, that would be very helpful. But in this case, I think she might have said, well, forget all those other names. Those make sense. But expectancy is another company right in your state, and they dropped it. I think she just, it appealed to her that this company did own it before. They lost it. They'd like to get their name back. But this guy didn't even let it drop and land softly, give them a chance to get it again. He just snatched it real fast. So I don't think it would have in this case. That's my opinion. What do you guys think?
I think probably not in this case, but it certainly makes sense to argue, yes, if you're the main investor and if you register, specific type of names, like can be surnames or names that start with X or any other, letter, then it definitely makes your case stronger if you can provide a pattern of registration saying like, look, I registered these domain names and I have hundreds of names in my portfolio, maybe 25 names in my portfolio, and this certainly works for many panelists. But again, it's a single member panel. I mean, in that case, maybe what the respondent could have done here, he could have selected a 3-member panel, and then he could have had better chances with a 3-member panel. But in a single member panel case, it's all very subjective, and eventually it comes down to a specific panelist that who is appointed by case manager. I mean, in that case, it's forum case manager, and sometimes it's like a gamble. Yeah, you don't know who you'll get, which panelist will get your case. But yeah, I mean, certainly these sort of arguments always help.
If you're a domain investor, if you say, hey, that particular week on expired names, I bought another 20 names. The week before, I bought 18. Now they're saying that you think that should help you, and it certainly could. In some cases, a panelist would think, all right, so this isn't the only name they were focusing on. But then it shows you're a professional domain investor. So now they're like, okay, well, don't murky the water with all these other names. You're a pro. You should know, you should check all these names, and you should know you can't get this one. All those others may be okay, but why didn't you know that this one's already? So it's like shooting yourself in the foot to let them know, hey, this is what I do for a living. I'm a pro at this. And they're like, fantastic. ACABs, thanks for joining us. What question or comment do you have?
Hey, hello, Todd. Thank you for bringing me on. Hello, everybody. I just joined in when you were talking about the expentesty.com UDRP situation where the complainant was, kind of warned the domain investor, which me as an investor, is not good news for me. I'm not so happy about it. But hey, it is what it is. So I want to ask, because I know you kept mentioning that this investor also lives in the state of Texas alongside just like the complainant themselves. So I want to know, so say for instance, this domain was bought under an LLC, and because I don't know if the LLC is registered in Texas. So, but say this client or this domain investor lives in Texas, and they have a Delaware, domiciled or registered LLC, and it was bought under that LLC. Would the domain owner or maybe the complainant who is claiming rights to this name, I mean, would that fact that this person lives in Texas, would that still hold water, considering that it was bought under their, maybe their public member LLC or multiple members or whatever, under in a different state? Would that still hold water? Would they still be able to get that domain name back from the the investor, considering the fact that it was registered under their business, which is domiciled and registered in a different state, even though they live in the same state with the supposed business. I don't know if I'm making a sense.
Yeah, I think so. David, what do you think about this? So if the LLC was actually domiciled in Delaware, I don't think it would make difference here. The company's in Texas. A lot of us, have LLCs in Wyoming, LLCs in other states. So would this have made a difference in how does this cross over into what you were mentioning before about getting a trademark with a holding company or an LLC?
Well, if the complainant said, well, we agreed to the mutual jurisdiction of the registrant's address in there, who is information, then you'd be litigating this case in Delaware, which is extremely expensive. So you don't want to be there. Wyoming requires an attorney. You cannot file on your own whatsoever. Arizona allows you to file and act on your own behalf if you get permission from the judge, but Wyoming will not allow that. So there's pluses and minuses. But definitely operating through an LLC will require that you have representation no matter what state you're in, because it's considered a legal entity. So I don't recommend necessarily going with LLCs. I'm doing everything under my personal name. If you're outside the country, well, then that's even better for you, because then if they choose your jurisdiction, then that's whatever country you're in. But yeah, these panelists are just making decisions any which way they can, especially this particular one. I've seen some that are very egregious, and she just won't believe you unless you put your statements under oath in an affidavit sworn before a commissioner of oaths or a notary. I don't even know if a notary works in the US, but yeah, that's what they want. And just don't give a general denial. Give searches. Go in Google search and say, hey, here's a search for expectancy, and then here's a search for expectancy plus Texas, and they still don't show up. They haven't been on Google for years. And look at their whois information on on archive.org. Sorry, their website history on archive.org. You'll see that it's not. It wasn't really developed that much before. So that's what you have to do. Just focus on those issues. Don't try to game it by running through an LLC.
Okay. Thank you, David. But you did mention something again. That brings me to a different question. I know Todd is about to run off this space, but you did say something about that you buy most of your name under your own name. Is that what you said?
Yeah, absolutely.
Okay.
Because if I want to litigate a situation, I don't have to pay an attorney. I can do it myself.
Okay. So that brings me to a different question entirely, because I, for one, I live here in the States, but most of all of my domains are under my business, which is an LLC, and So and the reason why I did it now, I might be wrong. I stand corrected. I'm also trying to learn. The reason why I did that was because when I do file tax and when I do make sales, I record that as my business. It's part of my business taxes, and it's part of the sales that I made under my business name, under my LLC. So but you saying that it's better to buy it up? It's better to maybe register these names under your personal. That's what you suggest, even with the tax angle that I just mentioned as a business. Filing, putting those maybe profits and and also expenses, that is expended in buying these names and maintaining these names. As now, I'm talking about tax angle now. As part of profit and loss under a business balance sheet. If you know what I mean, David.
Well, if you're somebody like Nat Cohen who has millions of dollars of sales every year, then yeah, using a legal LLC is probably better for you. If you're not in the United States, I don't necessarily recommend using an LLC. A corporation is better for tax
Okay.
purposes. But there's other ways to do this. You can handle it so that your domain is leased out to a corporation that actually uses it to generate revenue, and it can just take reasonable profits from that, and you're just leasing the names. There's so many new things you can do these days. Just don't think of just pure buying and selling. With AI now, a lot of domain names are actually selling a lot easier if you develop them somewhat, especially geonames.
You're right. You're right. Thank you for that. Thank you for the information, David. Appreciate you.
You're welcome.
And good question, Cabs, too. And, LLCs are taxed differently depending on what state there, and I'm talking about just U.S. stuff now, depending on what state the LLC is registered in. And David's right. He feels comfortable. This is for domain names, registering the domain name in his name. So then if there's ever an instance, a legal issue, he can answer himself. Because otherwise, you're right. You can't be an attorney if you're not an attorney on behalf of your own LLC or your own corporation. Now, that said, why do people set them up? Because you're trying to separate yourself, not make yourself liable for any issues that arise out of those assets. Now, if you're developing some out, that's different. If you're just a domain investor, well, people still want to sort of insulate themselves or make themselves not liable for anything that could happen with their domain investments. But David makes a good point. If you really want to be able to handle your own stuff, these small claims, or sometimes people just get themselves in a mess by going, establishing an LLC, creating one, and then they realize, okay, there is a legal issue. Now they have to hire an attorney. So if you don't have, attorneys on retainer or in your family, or you don't have a bunch of money to hire lawyers, always, be careful when you're setting up an LLC just to handle, just to handle things like your domain investments. Now you bring up to accounting, basically taxes, whole separate issue. Like I said, what state are you in? Why did you set up the LLC? There's, taxes will be different by each state, and there's some reasons absolutely why you want to do it. David said too, and I have a corporation, why you might want to have a corporation instead of an LLC, and then of course why you want to have some formed company as opposed to doing it as a sole proprietorship. But that's one of those things where everybody says, yeah, ask your tax person, and then just, hopefully you have a relationship with them. Then you can say, look at my past history of revenue I've received from these type of assets. Even if I've been doing it one way for a long time, they like for you to be consistent. If it's better to, maybe transition to another way because your tax professional said to, that's really for you and them. Everybody's situation is different too. And a lot of people don't make as much income off of domains as, they would like. And then many times your expenses are always, with buying names, hosting names, maybe some of these tools that you buy to build out names, you have a lot of expenses. So that's why you really want to bring those up to your accountant to say, I want to, write off as many of these real business expenses as possible. But then again, you may need to adjust how you account for the income that comes from some of these digital assets, basically your domain sales. All right.
Todd, can I just ask one more thing real quick?
Yeah.
When you mentioned, have you noticed, Igor or David, or anyone using AI to formulate their responses to these complaints? I was reading one of them earlier today that you have on your website, Todd, and it seemed like it was a canned response from an AI bot. And I'm just curious if that's going to be something that you see or have seen.
I can tell you that Claude 4.6, Claude Sonnet 4.6 is really good at responding to UDRP complaints and analyzing decisions if you use the correct prompt and you give it the right sources. So I always point it to the Internet Commerce website, blog, and udrpperspectives.org. And that grounds it with stuff that's real and it's out there. And of course, you should always double check everything that your AI produces. Don't just rely upon it and submit it. You have to read it and check every link, download every single case. That's the rules.
Thank you.
I've seen some AI, complaints and responses, and I've spoken to people who relied on AI in their conclusions. And here, I will be very careful. Yes, I think it's okay to use AI, but as David said, you have to double check, and you'd better ask a lawyer who understands the UDRP and domain names and trademarks, because just relying on AI would be too risky. And I recall I spoke once to a respondent in a UDRP case. He reached out to me and he checked, his case with AI. I don't know which AI he used, but he said, like, look, this AI tells me that I have 70 to 80% to win the case. And I checked the complaint and annexes and the domain name, and I said, look, I think you're going to lose it, and maybe your chance is like 10%. And I was right. And some reason, I mean, I don't know which AI he used, but the AI was wrong. So you have to be very careful. I mean, it's okay. And again, if you don't have if you don't have money, if you don't know any lawyer who can help you, I mean, it's better to answer, to send some response rather than do nothing. But just relying on AI would be too risky in my view. And yeah, so I would always say check, double check. And if you know someone who can maybe have a quick look, some lawyer, some professional, that always helps.
And I got to add too, it's like driving a big backhoe. Um, it takes two. They both said, double check, triple check. But still, I'm a believer that, I know some panelists who see an AI response and they're pissed that they got an AI response, even if all the citations are correct, even if it's a great response, and say it's all, airtight response. If they get a tinkering, I don't know the word I'm looking for, that they think it's an AI
The
response.
vibe. They get the vibe.
They're just mad that it's an AI response. And then David said it well, and that is, depending on your prompts, because you might say, listen, like you say, I want you to thoroughly, clearly, thoroughly, carefully go to udrpperspectives.org. I want you to look at this link here to WIPO 3.1, guidelines. I want you to look at, these cases, and you might even put, I want you to look at this particular case, and consider if these are appropriate for my response, considering I'm, wanting to defend myself in this manner. Okay, and then once you get that response, then to go, you want to double check these, cases that are referred to. I mean, bottom line is there's ways to use it and to, thoroughly sort of comb over and over. And sure, but attorneys all the time will file things with courts that have wrong citations. And then, you know why? Because it's fucking human error. So they could use AI to check their human errors to say, does anything seem inconsistent here? And it may or may not find it, just like a person in your office. I ran it by them and run it by a lawyer. They didn't find the error. AI may not find the error. But the point is, that's when you use different agents, different AIs, and then ask it maybe the same prompt or worded differently. But I think if you double check and you triple check, it's just a fantastic tool. It's like saying, you still want to use LexisNexis, you want to use Westlaw, you're going to want to use certain tools to do your research, because those tools are, more solid, more trustworthy than some other. You don't. You use Black's Law Dictionary instead of some dictionary on the web. But the point is, I think AI. That's the. I think it's a fantastic helper, even if you are somebody who writes your whole decision as an attorney, and then you ask AI, and they do. These lawyers are using AI more than anybody I know. And I know because I see responses from other lawyers, and you realize a lot of them don't know the small tricks that you can tell when they're using AI. And it's not bad. It's very helpful sometimes if they're saying, help me make this more concise, or with, especially when it's simple things like if there's any grammatical errors, do you see any misspellings? But I guess the point is, so yeah, I'm high on the AI responses, but obviously got to be careful. Just like when a human does, responds, they need a check. They need to be double checked just as much as an AI does. So that's how I feel. So it's like when a human thinks, well, yeah, double check the AI. Well, yeah, like I said, a person doing it, they need to be double checked. It's not like, you don't need to check that. I did that myself. Yeah. So the point is that it's just the tools are advancing. David mentioned AI Claude 4.9 or whatever. Anyway, they really are sophisticated. And if you give them the right prompts and send them to the right tools to look at, and then double check them, you're really in a great spot. But like finally, I'll say again, some panelists are just mad. I can't believe you think we're all getting replaced, and they're mad when they see an AI response, even if it's an airtight, all citations make sense, and they still just don't like that someone used AI. That's just how it is, and it's getting better now where they can't even tell. All right, well, that was a great show today.
I heard that 60% of U.S. judges are using AI already. So
60% of judges are using AI.
yes.
Yeah. Why wouldn't a judge go, hey, check this and see if there's any bullshit citations in here or cases that shouldn't be in here or mis referenced, and then when it brings up some, then they check it and they can go, oh, the AI was wrong. That is correct. But many times it'll be like, yeah, that's how judges do. I know, I mean, firsthand how judges find, hey, this is in your filing is incorrect. Go back. And then the judge likes to say, slap the hands of the lawyer, sometimes even worse, to say, yeah, you better check your filings before you submit these things. They're not completely accurate. And, the only thing you can do is double check with your, the guy that you're paying $900 an hour, and then double check with AI, and then go back and forth. But, no matter, even with AI and with the smartest attorneys, there's still filings that have mistakes. And, I just think the AI is making a lot less mistakes. Just like, we'll finish with the FSD, the full self-driving. People can't take it, but it's much safer than a human driving. But it's more of just the psychological thing. People can't take if, computer makes a mistake, but humans, are silly. But, yeah, so AI definitely for UDRP, I think enormously useful because it's not a court case. It's an administrative hearing, and if it's a name that hey, I'm selling this name for $2,000 or trying to, so I'm not going to spend $5,000 on a lawyer. It does make a lot of sense just to assist you. All right, boy, a long way just to say something simple. Thanks for being here. We're going to be here next Tuesday, noon Pacific, 3 p.m. Eastern. Josh and I have a pretty big show on Thursday, DNX show. A lot of new topics. If you're a domain investor, you're going to want to join us because we're going to talk about, what's going on in domain investing today, and we're going to share a lot of tips, Josh is, on how to improve your sales. So that's this Thursday, 10 a.m. Pacific, 1 p.m. Eastern, right here on X. So be sure and check it out. You can see the link on my timeline. But thanks for being here. Enjoy yourself wherever you're at. Thanks, Igor, a lot for doing this. I know it's late now. But thanks, David. And next week we will have Jeff with us. Until then, take care of yourself wherever you're at. That's it for today.